We are live.
Okay. Good morning. I'd like to call this special meeting of the Board of Education to order. The next Board of Education meeting is on Tuesday, August 26th at 7:30 PM. I'd like to thank everybody for closing out the 24-25 school year, and to those who have started off the summer with a bang, to the Darien Summer School and extended school year staff. Looking forward to seeing High School Musical at the end of the month. That's always an exciting way to close out the summer program. I'd like to extend a special welcome to Dr. Byrne, who retired from Rye and promptly got dragged into Darien, and we couldn't be more thrilled. Thank you for taking on the role of our interim superintendent. Dr. Byrne will be with us for a year as we look for the new superintendent. And again, we are so grateful to him for sharing his superintendency experience as we navigate through this period of time. To the board, our communication protocols will stay the same. If you have a question that needs to go to administration, please send it to Dr. Byrne with the chair and copy, myself and copy. And if you have a question about the board, continue to send it to the board as you were before, but our communication protocols are not changing. Just good time to reemphasize that as we again have someone new on board. And lastly, I'd like to extend a special thank you to the board, all of whom are taking this day out of their summer to be here all day long. It's a long day. So thank you to each of you for your service today and always. With that, I'll move on to the possible appointment of the Director of Elementary Education. Do you want to speak a little?
First, I'd like to thank the committee that helped to vet candidates and bring candidates forward. And did my recommendations that we have Ms. Jennifer Falcone, the Director of Elementary Education.
Great. And I will ask you to pull that mic a little closer to you for the future. Yeah, and double check that it's on.
Yep.
Okay, good. With that, may I have a motion to appoint Jennifer Falcone as the Director of Elementary Education? That is Joanna, seconded by Dennis. All those in favor? That is, okay, that is Sini, Parent, McCammon, Nelson, Maroney, Lublin, Brown, Walsh. All those opposed? Grambling. There are no abstentions. Okay. All right. Ms. Falcone, would you like, or Dr. Falcone, excuse me, would you like to say anything? You need to come up to the dais if you want to, so we can hear you. Thank you.
Thank you. I'm absolutely thrilled to be joining your learning community, and I look forward to meeting with all of you and focusing on our learners. So thank you very much and for trusting me in this important role. I'm looking forward to the work ahead.
Thank you so much.
Thank you.
Okay. With that, we'll move to legal updates and board operations. And with us, we have Tom Mooney, the attorney from Shipman and Goodwin. Thank you for being here this morning, Tom.
Good morning. As you know, I think been projected as well, but I've prepared a summary of some of the legislative changes. And just by way of overview, there's very little here to celebrate. But these are the changes in the laws that affect a school district operation in Connecticut. And the first was passed early in the session, Public Act 25-1. And it is a requirement that your school safety and security plan be amended to reflect the recommendations of the State Department of Education in terms of interacting with immigration officials. And as opposed to what happens in some jurisdictions, this is not a directive to withhold communication or to obstruct in any way. The guidance issued by the State Department of Education is essentially a protocol to make sure that the people who receive the district representatives who receive immigration officials, they show up and it's a protocol whereby that person understands that they can ask for credentials, they can ask the person to wait, they can check and you probably know that the ICE no longer treats schools as a protected area, so they do have the right to enter, but they only have the right to enter when they have legal authority. Otherwise, school officials can simply inform them that they are not permitted to enter school. So all districts in Connecticut have to have a school security and safety plan. From your perspective as a Board of Ed, you have to amend your plan to incorporate this new guidance. But again, it's just really a protocol, and it doesn't represent any, in my mind, significant change in the law. I'll pause as we talk about these things. I don't know if you have any questions about that before I move on to a rather detailed explanation of new changes in the requirements or the opportunities, I should say, for employees to take leave in various ways. So ready to move on? Okay. Just globally, and I don't know if Marge had to leave the room simply because this topic is too painful. It's just remarkable to me that the General Assembly each year thinks up new ways to authorize people not to come to work and in fact now be paid not to come to work. I don't want to be unsympathetic, but in the public sector, school districts have been quite sensitive and aware of the need for leave in certain circumstances. But now, as a matter of just directing how school districts should operate, there's a significant expansion in these provisions. The first two are the Connecticut Family and Medical Leave Act and the Connecticut Paid Family and Medical Leave. So Connecticut paid leave. There's also paid sick leave, which I'll talk about in a couple minutes, which is another new requirement under Connecticut law. But what's happened is that the provisions of the Connecticut FMLA and Connecticut Paid and Family Medical Leave, Connecticut Paid Leave, have been now extended so that all non-certified employees of boards of education are participants in this program. The two programs supplement federal FMLA, which is available to certain people who qualify by way of number of hours that they work. But for whatever reason, and I don't know if anyone has any insight into this, this expansion does not include teachers. And I know that teachers in Connecticut have significant influence in the General Assembly. So I really don't understand other than for whatever, well, we'll talk about one reason potentially. Under the paid leave law, you have the right to take paid leave. That paid leave is administered by a separate agency. We simply register. People apply to the authority to take the paid leave. They have a qualifying need for leave. They want to receive pay. But this is funded through payroll deduction. And now every non-certified employee is going to see 0.5% of their pay be deposited in this paid leave fund, which is administered by the paid leave authority. The Connecticut FMLA is now available where employees can take up to 12 weeks of unpaid leave for qualifying reasons. And so you have the right to leave. And in some circumstances, you have the right to be paid during the leave, which are separately administered. It's going to be quite burdensome to coordinate all of this. And I found it interesting in the statute, they always have to do like, what's the financial impact? And the Office of Legislative Analysis said there's no cost to this. And I don't know if Marge would agree with that. But trying to fill in for people who are on leave is going to be a challenge. The complication is that the FMLA is subject to different eligibility requirements than federal. And it's far more expansive for the employees taking Connecticut leave. They only have to be employed for 3 months. There's no hours requirement. So it's just very difficult. Now, what I've provided to you is a legislative update that 2 of my colleagues did. And I don't think it's necessary for us to go through all of the details of this. I just wanted to make the board aware that these new requirements are going to impose significant burdens on administration to administer and to reconcile the different qualifications and provisions of Connecticut paid leave, Connecticut FMLA, and federal FMLA. These changes will all be effective October 1st. So here we are looking at August. So it's going to be a challenge to get everything on board. Marge, I don't know if you have anything you want to add to this?
No, I'm waiting for Shipman and Goodwin is doing a webinar
Uh-huh.
to help people deal with the implementation. So I've been trying to ignore it until then.
Okay, well, we hope that will be helpful. And I know, as you mentioned, the state is going to provide some guidance as well. In addition to the expanding these programs to affect all of your non-certified employees, the legislature last year enacted the Connecticut paid sick leave law. And that affects all Board of Ed employees. It was, for years, it was simply service workers, which were a limited category. As of last year, the paid sick leave law applies to all board employees. And in a nutshell, the paid sick leave law permits employees to accrue 1 hour of paid sick leave for every 30 hours they work, up to a maximum of 40 hours per year. Now, that would be almost irrelevant to a Board of Education typically, because you do provide sick leave more expansively than that through all your different negotiated collective bargaining agreements and board policy. The challenge is that the paid sick leave law applies to reasons other than personal illness. We typically negotiate some level of consideration for taking care of an ill family member, but that's one, and they've expanded the definition of family. But it's also for preventive care, diagnosis, treatment, and I'm on page 7. if there's a closure due to some sort of epidemic, and even a mental health wellness day. So the General Assembly has decided that all employers should permit their employees to just say, well, I'm gonna take care of myself today and I'm not coming to work. Administratively, this law is a huge challenge because people don't have to give you advance notice and they don't have to provide any documentation. And there was serious discussion, sadly unfulfilled, but whether the practical implication for this law would justify exempting boards of education from its provisions. And we were hopeful that that would happen. It didn't. All that happened was that the law says you can take this leave in an hour increment. So an employee theoretically could say, you know, I'm just going to come in at 10 o'clock today. And I'm going to charge it to paid sick leave. The only relief that was given to boards of education, because when you think about, you know, you have a classroom of kids and a teacher would just say, well, I'm gonna come in at 10 or 11, and you have to worry about how do you take care of that. So, I mean, I don't want to be unkind, but it's just significant administrative burdens. The relief that was enacted this year for boards of education is that if you have a collective bargaining agreement, and if that agreement provides for leave in increments of greater than an hour, like half a day, or full day, then they can't take the leave in hour increments. So that's where we are with that. I don't want to sound like I'm just complaining, but on behalf of the districts I represent, I just have to say, it's easy for people in Hartford to decide public policy and what people should be able to do. The practical implications are significant. Do you have any questions about these different legislative initiatives?
I see that Greg has a question. John, perhaps it's something you could pick up in finance and just start looking at the model later when we understand it a little better. If there are any financial implications. Greg?
Just a question. You said that as it relates to this like incremental hour thing, if you put something in place with respect to your collective bargaining agreement, can you attach strings to that, or is it specific to just this item?
But what do you mean attached strings?
Well, like if you said they also have to give advance notice.
Oh, no, it's strictly the law permits people to take this leave without giving advance notice. We cannot require documentation. We can require them to tell us what qualifying purpose, but the moving away from the hour increment into something more like half a day increment, that's the only exception that's been enacted. And Marge reminded me that you, through negotiation, already have many contracts that talk about leave being limited to half day. And so you're in most places where we have to now negotiate that with the unions, because many collective bargaining agreements do not have that provision in them. You have that provision in some of your non-certified. I'm not sure if it's in the teacher contract. I don't.
It is.
Oh, it is. Oh, okay. Well, so that's a little good news in an otherwise burdensome law.
Joanna?
It says in your meeting steps for compliance that policy updates represent another major area of preparation. Is that just administratively, like you need to put in employee handbooks, or is that the kind of thing that also comes to the board?
I don't think that would apply the, mechanics to a Board of Ed policy, but I'm waiting to see if Shipman and Goodwin has a model policy. They don't yet.
Any other questions on this?
Just a follow-up on that, on the paid leave and FMLA, is that requiring an update on the board policy, or is that also an administrative, like employee handbook?
So our FMLA policy may need to be updated to reflect Connecticut, but I wait for Shipman and Goodwin.
Okay.
Okay, thank you, Tom.
There was also significant attention paid to the laws involving special education, and there were two separate statutes focused on that. And I think these changes are viewed in a positive light, and they're described here on page, starting on page 7 and going on from there. There's been a lot of attention to how districts work with private special education providers. And I would say that this new law provides for greater accountability because now the law requires that the private providers explain tuition and rates and fees, not just tuition and cost. And there's a schedule that the State Department of Education is going to come out with in terms of what can be charged for different services. And there's another provision in these laws saying that during the year, a private provider cannot increase the rates unless it's justified through the IEP process. There is attention to non-approved special ed facilities. As you probably know, there's an administrative process, and most special education schools are approved through that process, but some are not. The law clarifies that if it's a non-approved facility that is used to place a child, and I should back up. There's an obligation to place children in approved special ed programs. And the Supreme Court decided a case many years ago as to, well, what happens if a program is not approved? Are parents still entitled to have their children educated in that setting? And the Supreme Court ruled, yes, that's possible if that program is appropriate for that child, even if it's not approved. And so there are these circumstances where the best program happens not to be an approved program. But the new law clarifies that if a district makes that determination, then there would not be reimbursement. But if a hearing officer makes that determination, there would be state reimbursement. Shirley, I don't know if you have anything further you'd like to say about that?
Just to give some more color to that also. So currently, as you know, that PPTs can only recommend state approved programs. There are other communications that go on, and that's noted also with families in terms of, since we can't place a child in a non-approved state program, there are either agreements or sometimes a student is rejected from every state approved program that we ask for. And the parent needs to place the child in a sometimes it's either a residential program or a program that has different clinical levels. That said, recently there have been hearings where a hearing officer, to your point, Tom, has granted a parent has prevailed that they would pay, the school district would have to pay that non-state approved school for tuition or whatever the impartial hearing officer said. The new law would say that when that happens, if that were to happen, that those are not reimbursable. There's no excess cost funding that would be available. There's no relief to the district for that. However, it can go to the next level, which is if an impartial hearing officer and or court, I believe also,
Right.
offers that, then it can seek reimbursement for that.
Right. And my concern as I read this, and I'm not actively involved in special ed anymore, but my concern is this going to drive us to hearings in some circumstances where we need the blessing of a hearing officer in order to receive reimbursement?
It does suggest that that would be a course that a district would take because there's no relief for the district.
Right.
It also suggests, if you look at the other tier, that an impartial hearing officer would really have to really consider, so I'll give you the example of the other non-state approved school that just prevailed on that, that they would have to consider that there really was no other state approved program. So it would be arbitrary if the hearing officer just said, yes, I'm going to grant the parent the right to go to this non-approved school without really reviewing all the other opportunities of state-approved schools. So there's a different burden of proof, I think, on the hearing officer also in terms of making that determination.
Mhm.
So I think that both things will happen. One, districts might seek to go to impartial hearings to get excess cost reimbursement. And two, I think impartial hearing officers will need to consider a different tier, a different level of consideration
Yes,
before making the decision.
right. And are the board members all familiar with this concept of excess costs?
Yes.
Yeah, okay. As you see on page 8, there are a number of new grants. One of,
Sorry.
of course,
Just, this is, it's a little confusing to me. Does this also apply to unilateral placements and settlements? So, okay, so this is just for when the school is placing the child.
Right, it doesn't, unilateral settlements are confidential and are not part of this.
there are a number of new grant programs, and one that I find particularly interesting is to support in-district special ed programs. As you all know, children with disabilities are entitled to be served along a continuum, always looking for the least restrictive environment. And an out-of-district placement is one of the most restrictive choices, but sometimes that's necessary. But many districts are now focusing on, well, how can we better serve children in district and avoid the need for an out-of-district placement? And there's a state grant now available for this. It's a competitive grant, so it's not necessarily available, but districts can apply to work to support in-district special ed programs. There's an interesting dimension to all of this, and that is in educational funding generally in Connecticut, we now have what's called the minimum budget requirement. And towns appropriate funds to permit the schools to operate. Going from year to year, subject to certain statutory exceptions, the town is not permitted to appropriate less than it did in the prior year. On occasion, districts have received supplemental appropriations for the cost of special education services. And those appropriations have then affected the minimum budget requirement because it was in a part of the appropriation process. And so that has caused some tension where you need more money, and towns, I'm not saying Darien would be one, but towns are reluctant to provide the money because then it ratchets up the minimum budget requirement. In several of these instances, accepting these grants does not affect, expressly does not affect the MBR. So it avoids that particular problem. Another question for Shirley, when I look at the bottom of page 8 about instructional support partners, some districts have people serving in these roles. Does Darien have this? No?
Not at this time.
No. And interestingly, as you see here, the legislature paid attention to this position of instructional support partner for each school or school building. And that designated person must spend at least 50% of his or her time on the following, and you see the bullets here reducing administrative burdens on teachers related to the IP process, helping improve the delivery and administration of the IEP process, collaborating with parents regarding instructional decision-making, pursuing and attending professional development, and consulting with school-based instructional staff. What I found interesting is that when the General Assembly took its first pass at this, they said by next year, you're all going to be required to have these positions. For whatever reason, apparently they had second thoughts. And they, in a subsequent law, Public Act 25-174, they made this new position optional. So it's not required. And I don't know if over time you would have any interest in these positions, but it's one state mandate that never took effect because it's now optional. There's also attention to developmental delay, and these statutes increase the scope of children who may be identified as having developmental delay from 3 to 5 to 3 through 8. And that's a part of the PPT process. And I talked briefly about the fixed annual costs and
Hey,
the
Tom.
rate setting.
Before we jump to fixed annual costs, can we go back to I think Dave has a question on the
Minimum
class
budget?
Yeah.
So Tom,
Okay.
going back to the minimum budget, the question I had was, you were talking about appropriations.
Right,
So the appropriation is 10 this year, it can't be 9 next year in theory.
correct.
If 10 is appropriated and we wind up giving 1 back to the town, making effectively 9, is that okay? It's really the appropriation. It's not that I have to spend all 10, correct?
That's correct. But you're also, your question invites acknowledgement of this expanded right to have a non-lapsing account. Boards of Ed have now, in the last 2 years, I think, have an expanded right when you don't have, when you're coming to the end of the year. The problem was that it's use it or lose it. And Boards of Ed would, like in May and June, look around. We had a good year. And so what should we buy? So now it's probably 8-10 years ago, Boards of Finance could create these funds. As of last year, Boards of Ed themselves can create these funds and deposit up to 2% of your appropriation to this non-lapsing account. Back to your question, it's always focused on the appropriation, not on the expenditure of the MBR. But if you come to the end of the year and have not expended all the funds, if you do nothing by operation of law, the unexpended funds revert to the town, because on July 1, you get a new appropriation and you start over. But this new law permits Boards of Ed to now transfer those unexpended funds up to 2% of the budget to this non-lapsing account, which then can moderate budget problems in future years or be used for capital improvements or maintenance or whatever.
Thank you, Tom.
We talked about the rate setting, these efforts to limit costs by private providers. We see on page 10, there are further requirements concerning making changes in out-of-district placements, new reporting requirements to the State Department of Education. As you're now implementing the new bullying legislation and have this new concept of students with challenging behavior, before a student is placed out of district for challenging behavior, there's a general requirement that functional behavior assessments or behavior intervention plans be developed for such students unless that student's behavior creates a safety risk. Even though I don't do special ed hearings anymore, I was pleased to see that there's further rigor added to the due process hearing process. Now, everyone has to, before the hearing starts, put all the claims out that they may be making. And hearing officers are required to consider all evaluations. What I found most interesting is that I mentioned earlier that the hearing process has evolved to quite a complicated litigation type practice. This legislation intends to limit hearings to 4 days unless the hearing officer decides there's good cause to lengthen it. I hope that this new focus will expedite the hearing process, but it's not an absolute, and in fact, it couldn't be as a matter of due process. You have to take the time it takes, but I think this gives hearing officers incentive to let's move it along and get through the hearing process in a more efficient way. I think that's those are the highlights, but as I said before, these two legislative enactments are viewed positively as appropriate for both school districts and parents to work together more successfully. Shirley, I don't know if you have anything further you'd like to add about these particular changes?
No, I would just add to what you said originally, Tom, which is I think the idea of rate setting and looking at private schools and private programs being required to set a rate is reasonable because they're in terms of looking at their tuition, looking at their related service costs, because some of them are really quite extraordinarily high. And school districts can't necessarily be able to provide what the program would be. So I think the idea of having some compliance and responsibility, to your point, will not change the services for students, but I think they'll look at the rate setting to be a positive thing. It's set in other states. There's rate setting in New York. There's other rate setting to really look at those services. And parents were concerned, will it take services away from students? And again, it won't. It'll just have some authority and some compliance over that, including requirements, including certifications, including different aspects of those programs. So all students can have access.
Thank you. Any other questions before we move on? The other legislative changes are not all that exciting, but we'll touch upon them. And if there are no other questions about the special ed changes. In student discipline, you see here Public Act 2593. Now, there's a requirement if the district administration is intending to suspend or expel a student, there's a requirement that there be outreach to the local homeless educational liaison to determine if the student's homeless. And if so, consider the impact of homelessness on the student's behavior, and expulsion is not permitted of a homeless student unless there is a plan of interventions and support to mitigate the effects of homelessness. Does Darien have a homeless liaison? So you have these new responsibilities under the law. Nationwide, there's been obviously concern about library materials and this new legislation in Public Act 25168 interestingly is not prescriptive but rather procedural, but it does require that boards of education adopt three new policies: a collection development and maintenance policy, a library display and program policy, and a library material review and reconsideration policy. Each of those policies have to take into account the prohibitions against discrimination in Connecticut law, which include discrimination on the basis of sexual orientation or gender identity and expression. So the policy committee here will be looking at those as a requirement, and I'm presuming that my colleagues at Chipman and Goodwin will be suggesting model policies, but model policies are just that. And I'll just say policy decisions are different from legal decisions. Legally, you have to have a policy. What that policy says is going to be something that is left to the Board of Education, as long as you take into account the requirements of section 1015C. But that is something that you'll be addressing in the future. There's also a new requirement that your curriculum committee post objectives and scope and sequence of approved curriculum starting in the next school year. So this just builds upon a requirement that has been in effect, that school districts must have a curriculum committee. Now that committee must be posting objectives and scope and sequence of approved curriculum on the district's website.
You have a question, Tom?
Yeah, I had a quick question. I think this is probably directed at Amy with the July 26th timing in EduPlanet work. And, this is just scope and sequence and the requirement, just asking, if that's going to have any impact on where you are with that work.
No, we should be all set to produce stage 1 in EduPlanet for public consumption.
Awesome. Thank you.
That's the core areas. So the one area that's behind right now, I would say, is like PE. We've taken care to make sure that health curriculum has been written. So grades 7 through 12 will be up scope and sequence for, actually, I think it is already for grades 7 through 12. So we're making good progress.
Awesome. Thank you.
You're welcome.
Any other questions on that? The last legislative enactment that's listed here is just more mechanical and would not directly involve the board, and that is the administration of epinephrine and glucagon may now be delivered through a nasal spray. So this just gives additional flexibility in terms of addressing the urgent medical needs of children who are either having an allergic reaction or an issue of blood sugar. So those are the legislative changes. As you can see, they spent a lot of time working on ways that employees can now take additional leave. But compared to some prior years, the other legislative changes, other than the special ed changes, are not all that significant. I did want to bring to your attention two cases that are particular, have significant implications and are particularly interesting. Who here heard about the Mahmood versus Taylor decision? It's been in the press. And when this, just to give you the overview, the Montgomery County, Maryland Board of Education adopted a variety of LGBTQ plus inclusive storybooks into the elementary school curriculum. At the risk of editorializing, I would just offer the observation that bad cases make bad law. What Montgomery did was they adopted this curriculum, told parents they could have their children excused from this curriculum. And then a year later said, never mind, you can't be excused. And your kids have to participate in the instruction in this regard. And to make matters worse, in terms of just the challenges this case posed, teachers were given specific guidance as to how to respond when a kid would say something like, well, a boy can't be a girl. And the teachers were given guidance to say, that's hurtful. And so that case came to the Supreme Court. The parents said that their religious rights, their rights of religious exercise were being unfairly limited because they as parents have the right as a matter of religious expression to raise their children in their religious traditions. The argument at the Supreme Court was a harbinger of how it came out. After the argument, the questions to the justices made it pretty clear that the justices felt that the Montgomery County Board of Education had gone too far in adopting this curriculum and saying to parents, you can't excuse your child from the curriculum. And so on a 6-3 vote, the United States Supreme Court ruled in favor of the parents. And interestingly, they relied upon two very old and well-known cases. One was West Virginia versus Barnett, which was decided in 1942. And it had to do with a child who was a adherent in the religion of the Seventh-day Adventist, Jehovah's Witness. And West Virginia, this was in the middle of World War II. It's really a remarkable decision. The child was told, you have to pledge allegiance. And the child said, well, that's against my religion. I can't pledge allegiance to anything but God. And he was expelled. And it became a Supreme Court decision. And in his favor, the court ruled. And what's so interesting is it was at the depths of World War II. You know, it's hard to imagine. I wasn't around. I don't know. But, you know, in 1942, it was shortly after Pearl Harbor. It wasn't, the results of the war were not at all clear that the United States would prevail. Yet the Supreme Court ruled that you cannot compel patriotic speech. And this was an acknowledgement of the rights of people to freely exercise their religion without government compulsion. In the other case, the court relied upon was West Virginia versus Yoder. I'm not West Virginia, Wisconsin versus Yoder. And it had to do with the Amish tradition of having children leave elementary school at age 14 and then be educated at age 14 in manual labor and craft and construction. And that was their culture. And the state of Wisconsin said mandatory education ends at age 16. We now in Connecticut, it's 18, but you know, for many years it was 7 to 16, and that was true in Wisconsin. And so you parents are in violation of the law by withdrawing your kids from school at age 14 after they complete elementary school. Well, the Supreme Court decided that in balancing the interest in mandatory attendance against the cultural impact of requiring that the Amish change their traditions and enroll their children in high school, at least for the first 2 years, was a violation of their religious rights. What's particularly interesting is that the Yoder case has been viewed since it was decided in the seventies as a unique circumstance, not really replicated, and other religions had tried to get similar excusal from educational services. And it was like the Amish exception. Nonetheless, in this case, the court focused on Yoder and West Virginia versus Burnett to say that parents have a significant interest in the religious upbringing of their children, and government can interfere with that only if government shows that there's a compelling need to do so and there's no other way to do it than to intrude into the right of parents to direct the religious upbringing of their students. Some of you have probably heard of the Kennedy versus Bremerton case. If I tell you about the football coach who needed to pray on the 50-yard line, that might refresh your memory. And all the smart money was he's going to lose because I never played football, but I know enough to know that playing time is important if you're a football player. And if I were a kid interested in playing time, I would be praying right next to my coach on the 50-yard line. And so we were quite sure, I teach school law, and so, it's like pretty clear that this is an undue influence that this coach would have by right after the game praying on the 50-yard line. And in fact, students had joined him on certain occasions. And so he was told, you can't do that. He says, I got to do it. He did it. He got fired, went to the Supreme Court. And as I'm indicating, we all thought he'd lose for sure. He didn't. He prevailed. In a strongly worded opinion, Justice Gorsuch said that his right to pray publicly on 50-yard line immediately after a game was double protected by the free speech clause and the free exercise clause. And the analysis says, well, other coaches, the game's over, they're off duty. Other coaches are checking their email or text messages, and Coach Kennedy was praying, and he had every right to do that. And in so doing, they also abolished, this is 2021, the Lemon Test, which for many years governed how we analyze religion in the schools. You ask, is there secular purpose? Does it advance or inhibit religion? Does it entangle us with religion? The Kennedy case abolished the Lemon Test, said we're not going to follow that anymore. We have to follow cultural traditions and figure it out from there, which is not much guidance, by the way, for us. So they talked about Kennedy, they talked about Yoder, they talked about West Virginia versus Barnett. And the majority of the court said that the requirement that children participate in these educational programs, which the court defined as normative. In other words, it's not just information, but rather inculcating values, burdened the free exercise rights of the parents who were the plaintiffs in this case. And so, and in fact, interestingly, whenever you burden a constitutional right, it also has to be narrowly tailored to achieve this compelling interest. And the court said, you excused them before, so why couldn't you just excuse them again? And so why this is so important to all of us is that now we wonder, where does this go? Respecting a parent's right to direct the religious upbringing of their children, where are we going to draw the lines? I think it's appropriate to read the Mahmoud decision narrowly because we're talking about kids in grades K through 5. We're talking about normative education where values are being imbued in these children, and parents of certain religious faiths felt that that was inconsistent with their view of the world. And there was so it remains to be seen how this plays out and what, if any, impact you're going to see here in Darien with parents asking for excusal. We did have a vehement dissent, but on a 6-3 vote, this was the decision of the Supreme Court, and we'll wait to see. Just one last point. Under Connecticut law, parents do have the unilateral right to have their children excused from instruction in 5 areas. Family life education or sex ed, HIV instruction, dissection, sexual abuse and assault awareness, and gun safety program. So parents can unilaterally be excused from that. I think the challenge in the Mahmood case is that because of those exceptions, those are all pretty discrete. You know, in the health curriculum, they set aside certain units for family life education. So you know that this child is subject to excusal during those classes. The question here is, how is this going to play out through the curriculum? What areas in the curriculum are parents going to assert a right of excusal? And on a purely mechanical level, how is that going to work in terms of delivering instruction to students? So a lot remains to be seen, but it's a significant decision. And I'm happy to answer any questions you might have about it.
Any questions, Greg?
I'm interested in hearing your thoughts with respect to this Supreme Court decision vis-a-vis the state new law that you described regarding library materials and programming. So I could imagine a situation where a parent objects to being able to view certain materials that are present in the library to all kids.
Yes.
But the state here may be saying, you're not allowed to remove the books. So how does that work?
But the state or
This
the,
library, Public.
oh yeah,
Act
the library
25,
materials.
168.
Well, there's
Those seem to be
definitely,
potentially competing.
there's definitely tension there because the law expressly incorporates the provisions in section 1015C, which say that the schools may not discriminate against children on the basis of their race, religion, sexual orientation, gender identity, and expression. And some courts have ruled that removing books dealing with those topics from the libraries is discriminatory because exposure to those ideas is part of the issue of sexual orientation. So you've just identified a tension. I will say the difference between that circumstance and the Mahmood decision is that the court really focused on the normative educational aspect of the curriculum as opposed to something in the library which is there available but not being used directly to instruct children. So there's definitely a tension. And in fact, we're going to see that tension play out in the next case I'll be discussing, which is the Sewell case. But happy to talk about any other questions you might have about Mahmood. No?
No,
Okay.
thank you.
Well, then the last case I just wanted to bring to your attention, and then I have some topics for the board to discuss is the Sewell case. And this is the definition of being between a rock and a hard place. Because Connecticut has a law providing that, and it's been around for 14 years now. Gender identity expression is protected, can't discriminate against a person on the basis of their gender identity and expression. And so that has played out in the interscholastic athletic competitions where CIAC has a rule in accordance with state law permitting children to play on the teams on which they, of the gender with which they identify. A number of school districts had transgender athletes. It's not common, but a number in Connecticut did. And students who competed against those transgender students sued the CIAC and a number of local districts claiming that Title IX was violated when they had to compete against students who were born male. So that case has been ongoing for several years now. We're representing the CIAC in that case. We also represent some of the defendant school districts. The case was dismissed. The Second Circuit reinstated the case. The case now is alive for further litigation. Meanwhile, the Trump administration has, there's an executive order about gender, and the Trump administration has come after local school districts with demands that they adopt rules prohibiting transgender students from participating in sports. So this is going to the Supreme Court. And so right now, we're just really in this impossible situation where the Biden administration interpreted Title IX in one way. We have this state law on gender identity and expression. So everything was pointing in one direction. Now the Trump administration says, no, Title IX has to be interpreted to protect children born as female. And the Trump administration is pursuing that through separate threats of litigation. So I can't come soon enough from my perspective, but both Idaho and West Virginia adopted laws prohibiting transgender students from participating in sports. And in both cases, those prohibitions were enjoined by the federal courts. And now those cases, the Supreme Court just agreed to hear both those cases. So we're going to get an answer. And I think that's the most important thing. But it's a very challenging situation right now. Any questions about that?
So we're in a period of a lot of legal, as you said, a lot of different legal things, legal flux or legal opinions at different levels pointing in different directions.
Yes.
What advice are you giving to boards of education in terms of how we think about our governance?
The assertions of the Trump administration are, many people hold those views, but those are assertions as opposed to laws. And we have in Connecticut laws protecting children who are transgender. Our advice is the law is the law until someone tells us not, that it isn't. There is in constitutional law, the supremacy clause, so that if the Supreme Court decides that this is the way Title IX has to be interpreted, and state law conflicts with that, state law will have to yield. But we don't have that definitive ruling right now. So we're advising districts to follow the law and keep your head down. We will have an answer in the next year.
Other questions? No. Okay,
Okay, well then, I just, in the last time I have with you, I thought I would just identify some operational issues for your
Sorry.
discussion. Yes.
Sorry, excuse me. Going back to the library, Greg's question, the library books. Is there a way that we could implement a policy in which allows parents to say they don't want to see their child take out Tom Sawyer or something? They can put it on a restricted list for their own child. I think Newtown, recently, like within the last year or two, might have done something.
There
like
was
that.
quite a controversy
Right,
in Newtown.
right, but I think they ultimately landed with a policy in which allowed parents to specifically put a list at the librarian table to restrict their children, not all children. Clearly.
Yes, that's all true. I would have to answer that question with the generally applicable legal answer, which is it depends. And just, there's another case out of Arkansas where a school district put the Harry Potter books on limited reserve and required that parents authorize children to
Right.
take, and that was struck down. And the court said that children should have the right under the First Amendment to access that without that interference of the adoption of that parent requirement. That all said, some of the books we're talking about are very different from Harry Potter, and that's the it depends part.
Sure.
And so I would expect that a school district that makes reasonable judgments about the developmental stage of children and access to information, those reasonable judgments will be upheld and that within reason requirements that certain materials be accessible only through parent permission would be upheld.
I'm going the opposite way, though.
Okay.
I'm saying all books available unless a parent disputes restricts the use of.
Oh, so, yeah, that's interesting. So there's two ways to do this. Either the district identifies the books that will be accessible only through parent permission. And you're saying that parents would unilaterally say, I don't want my kids having access to this, that.
To this book, that book, and another book can we legally implement a policy like that?
I'm struggling a little bit between can you and should you.
I didn't ask should.
Right. How would that even work?
It's just like my kid can't take out rated R movies. I mean, you'd have a reasonable list of individual books that a parent doesn't want their child to take out. So when they go to the library, swipe the card and there's a list of books that might not be appropriate.
But you'd have to keep track, you'd have to keep track of the parent preferences for each child.
Those that wish to show preference.
Yeah, and that's true. I don't want to exaggerate. There may not be that many.
Yeah.
Well, without doing any research, based on my experience, I would say that would be a legal policy if you chose to do it.
Okay.
But I was also surprised by the decision that removing sexually explicit books in some cases was viewed as a First Amendment violation. And the case out of Arkansas.
No, it's clear. We have to navigate a lot of different ways here.
Yeah,
So
you have practical issues, but and as a general premise, I think a Board of Ed would have the authority to authorize parents to convey restrictions if you chose to do that.
Thank you.
Greg?
Just one other quick follow-up as John was talking, just made me think. Do the books in the library for the schools require specific board approval? Like other curriculum is required, like we
There's no
require?
statute that requires that educators get Board of Ed approval to acquire a book for the library.
How are they different than books in the classroom?
Well, boards of ed are expected to have a curriculum committee that adopts and approves and revises a curriculum. And so the board would have that oversight function for curriculum. Boards could exercise an oversight function for library books, but that's not mandated by statute. And for what it's worth, where we draw the line in terms of removing books from the library is uncertain.
Yeah, I was going towards more, how did the books get there in the first place?
Yeah, I understand.
Not how do you remove them, but you would think that there would be some approval process for any book, irrespective of what it
Yes,
is.
and-
You know,
and
like,
I'm-
you can think
I-
of some really bad books that you say, yeah, that doesn't belong in a kindergarten's library,
Right.
right? So my question isn't how do we, like, what happens, how do you remove them? It's more like, how did they get there in the first place?
Right, and my understanding is that that would typically be a decision made administratively by the educators, and that there's no, and I know that there's no statutory obligation for educators to get Board of Ed approval before they acquire a book for the
So
library.
do you think that Board of Ed should have a policy in place around approval of books in libraries?
I think that wouldn't that be one of the
Yeah, you have to have a collection development policy.
So that's one of the new, that's the part of the new. I know we don't have that, but
yeah, but that's
specifically.
coming,
That's what we're waiting for the models, right?
right?
Excuse me, Katie?
Hi, I just want to make a suggestion. Considering that the topic on the agenda is about legal updates, I think that we have talked for quite a while about the legal developments and conversations about how we are operating our districts and how we are, what is available in our schools and exposing, I think could be moved to more of the board's internal work on what the board role is and is not, and as well as what our curriculum is, what expertise we have and we hire for. I also just want to say, you know, to be careful, I think that we need to be very careful about the scope of our work here in that, you know, we don't adopt a new curriculum every year. And we can see just from the process that we went through, we spent 2 years being very, very thorough. Curriculum is something that goes in front of every student versus library books that kids might read for pleasure. They might check out for certain things. Not only are lots and lots of books written every year, but also if the board were to take that on, are we going to review everything that's existing? And I can tell you that I wouldn't be confident ever opining on a book that I myself haven't read. So I just think that maybe this conversation could be moved to a more appropriate place in terms of the board role and curriculum scope.
I'm going to disagree with you. I think that it's appropriate here and I'll let it go. Go ahead, Greg.
Yeah, I'm more focused on, do we need a policy? Because that's what it seems the state mandate is saying we have to have. So irrespective of reviews of the books and what we have to do, if the state is now saying we do, then I agree, Katie. I do think we should be talking and getting your input as to at what point the Board of Eds stand up against state mandates that they don't agree with, because you can come up with some pretty wild state mandates that could come through the pipe. And I think you've been questioning a lot of the things that they've been coming up with recently as it regards to what is the impact on actually operating as a district. are they actually realistic to be able to implement some of these mandates? So I think that is a question in terms of like, as a board, like at what point do we put our foot down and say, no, this doesn't make sense?
We have to follow along. Tom, do you know when these model policies will be out?
I don't.
Okay.
I don't know when this, I mean, this was just enacted.
Yeah.
And I see collection, development and then maintenance policy, so I think that would address your
Exactly.
question. What that policy says, and who approves what is, a policy judgment, whether it would, what would come to the board and what would be done administratively.
When does this have to be implemented by?
I can find that out. I don't. They pass these laws. I'm not sure. Let me find that out.
Okay.
Okay. All right, any other questions on the legal update? And the implications thereof? Okay,
Did you want me to just briefly address the last pieces here on the
please.
update? Well, you've welcomed Dr. Byrne here. Pleasure to work with you. But one of the questions that comes up with boards of ed is, what is your communication protocol when board members, for example, want information? How would you expect as a board, your superintendent, to provide that information? And I don't come here telling you how to do business, but rather identifying this as a issue for board discussion. So what are your expectations?
So Eric, I think you, in your interviews with board members, had a couple questions about communications. You want to cue this up a little more specifically, please?
Sure. Well, thank you. And I do believe that in your report, you spoke to it at the beginning of the meeting, which is inquiries or questions that board members are looking for information would be an email directly to me, copying the board officers. And I think that's just rather than going directly to other administrators, the communication would come through me, through the board officers, and I would respond to all and get that information back to individual people. So it's just a matter of, for my own purposes, being the new guy here, understanding what that policy is. I think it's always important that everyone's clear and on the same page with that at the outset of a relationship.
One clarification on that. So in the past, we've had just subcommittee chairs going, I'm chair of the curriculum subcommittee, so I would email Amy directly with the chair and copy. Is that still fine in your book?
To me, that makes total sense. Existing practice for chairpersons of committees, that seems absolutely reasonable from my experience.
With the superintendent in copy also?
Yeah, that's what.
Yeah.
You said chair, so chair. and
Oh, sorry,
superintendent.
sorry.
Yeah.
Both.
Both, yes.
Yeah, just clarifying. Okay. Anything else on communication protocols? Okay. All right, Tom, freedom of information issues.
Yeah, we talked some about the Freedom of Information law during the update, and how you have a log for records requests, and those are dealt with administratively. On the meeting requirements, I just wanted to offer the observation that email has been, the Freedom of Information law has permitted people to weaponize requests for email. And it's just terribly important to remember that anything dealing with the operation of the Darien Public Schools that is recorded is a public record. And I was at the commission a couple of weeks ago where 10,000 pages of records were the subject of a response to a request for email. So you just have to be careful about what you put in, and is it your practice when you communicate on board business use the Darien server as opposed to your private email.
Yes.
That relieves you of a significant burden because then it's an IT issue and it's not a matter that falls upon you as a personal responsibility. And the law has evolved. We're now 50 years into the Freedom of Information Law, which was passed in 1975. And when you think about what records were like in 1975 and what records are today, it's remarkable. So what's evolved is a whole process of search terms, because no one can go through 1 million emails other than electronically. And electronically, you decide what is a diligent search, what terms should your IT person plug in. But as we touch upon the Freedom of Information Law, I also just wanted to mention text messaging, which is a problem. And I'm sure you're innocent, but there are some boards that have group texts among more than, or at least a quorum of the board. And there can be an inadvertent violation of the Freedom of Information Law. Because as soon as you have a quorum communicating, whether it's by text message or by email on matters of board operation, that is defined as a meeting. And obviously you're not going to post a text exchange. And so that has been a problem encountered by some boards where they have a text chain and they have a quorum of the board on that chain, and someone eventually asks for text messages and uncovers the fact that there have been illegal meetings of the board. I don't know if anyone has any comment on text messages and how you do your business.
No, thank you.
No. Okay. And the last topic is really separating social media posts that are district generated and social media posts that are not. I'm presuming that different aspects of the Darien Public Schools have a social media presence.
It's fairly limited, but there's some minor, yeah.
Do you have a Darien Public Schools Facebook page?
We do not.
We do not,
No?
not as current.
Uh-huh.
On my time.
There are aspects in which, you know, you have teams have their own Instagram accounts, Facebook accounts, and, you know, clubs and that sort of thing. But
PTOs, yeah.
they aren't directly administration running them. In many cases, it's actually parents, coaches.
Yeah. And I haven't heard of controversy related to social media for sports teams. I have heard of controversy where a government official has a social media presence, or a governmental entity has a social media presence, and they then block certain people. And the courts have held that if a public entity creates a forum for speech, then you're under the First Amendment. You can't discriminate against people on the basis of their viewpoint. So a practical answer in these cases is disable comments before the trouble starts. Because if comments are permissible, that's a forum, and you can have people saying things that are unkind or rude or unwelcome. The rules are completely different for individual board members. And the involvement in social media by members of boards of education runs the gamut. I don't know if you have any particular concerns here, but as long as it's clear that board member is speaking for him or herself, this is just an exercise of free speech.
We've gone round in circles somewhat about social media and board members. We've had a variety of different ways in which board members have used social media over my 9 years, but we aren't generally on it. We're not on it together in any way. And sometimes we may like what another board member says and sometimes we may not. My understanding of the primary restriction is that, you can't be in quorum in any way on social media.
Yes.
I think the other question that comes up is the fuzzy one that you talk to us about a lot, which is when one of us opines on something on social media, whether or not the other board members agree. That usually is what makes things bubble up.
You have to make it clear that you're speaking for yourself, or you should make it clear. You don't have to.
I didn't quite hear.
You should make it clear you're speaking for yourself and not for the board.
Right.
Katie?
Thank you. I would be interested to hear what the legal guidance would be in terms of a code of conduct. We have been working on developing a handbook. We've had conversations about this in the past, and it's never gotten to a place of policy. And even currently, really, the only limitations on board members are financial, which I think is a very low bar. I hope, and I think that most board members do hold themselves to a higher standard of conduct. But I am curious about how we might be able to better instill a sense of integrity for the board, and how the actions of one, even understanding free speech, even with the disclaimer of speaking for one, how certain actions and comments can impact the board as a whole, specifically, again, as it relates to code of conduct and integrity. Could you just talk a little bit as far as like what kind of guidance you might give us?
Well, I haven't been elected to anything since 8th grade, so I have to refer to how you want to operate as a board, but I can more constructively point to the fact that the Norwalk Board of Education adopted a code of conduct, civility as part of that. And I think it's intended to provide guidance to board members in terms of how to interact. The enforcement mechanisms are limited. When you're elected to the board, the courts say the remedy is at the ballot box, and they're not going to get involved. Under Robert's rules, there is no procedure for removing a board member in Connecticut. Under Robert's rules, there are disciplinary procedures, but they result potentially in a censure, an expression of disapproval, as opposed to any limitation on the board members' right to participate in all board activities. But I would recommend, I know that the Norwalk Board of Ed, this is now probably 15 years ago, was going through some troubles, and they adopted a code of civility, and I think it's still in place.
We do have some sort of civility policy, but I think to your point, it's not enforceable. But what I'm curious about is the one time that we did have a social media post that I found particularly complicated was a time when a sitting board member was interpreting a policy incorrectly and posted that on social media. What have you seen boards do in that instance?
I don't have a lot of experience in that, so I can just respond in the abstract. The First Amendment dogma, and I personally subscribe to it, is the response to speech is more speech. So if someone is incorrect in a public statement, I think sharing a opposing view and is the right and perhaps the responsibility of the board members, of the other board members, to make sure that that accurate information is prescribed. And obviously, some of this could just be inadvertent and unintentional, and polite conversation about problems like that could be productive. But if polite conversation doesn't lead to a correction, then the other board members would have the right to issue their view of the accurate information.
Thank you. Any other questions on this topic?
Well, I think that we've timed this perfectly, because I think I was supposed to leave in 2 minutes.
Oh, good.
So enjoy this free time.
Thank you.
And I know you have a full day, so thank you for your patience and listening to me.
Okay. Thank you so much, Tom, for being here.
My pleasure.
See you soon.
Yes.
Yes. All right, I suggest we move on to public comment and then take a brief bio break.
Good morning. If anybody in person or online would like to participate in public comment, please approach the podium or use the raised hand icon and wait to be recognized by the chair. Please note that you have up to 3 minutes to speak and state your name and address for the record. We have no raised hands or nobody in the audience.
Okay, with that, I'll take a motion. Well, actually, do you want to take a motion to recess for a few minutes? Yeah, we could do that for about 20 minutes. Okay, that's Dave, seconded by Katie. All those in favor? Thank you so much, Tom.
Thank you.
Okay, so we'll reconvene here at 35. Great. I'll take a motion to reconvene to reconvene. That is Sarah, seconded by John. All those in favor, that is unanimous. Thank you. And we will move to the superintendent's report. Thank you and welcome.
Thank you very much. So first, I'd like to express my appreciation to the members of the Board of Education and the administrative team for taking the time to meet with me last week. As I've shared with the community, I'm implementing an entry plan, and a critically important part of it is to meet with lots of members of the Darien community in an effort to learn as much as I can about the schools and the community. Last week, I spent a good deal of time meeting with the BOE members and the administrators. I did have a chance to meet with a few parents as well, and it was all incredibly helpful. So far, and I'll share this in my reports over the coming meetings, I've conducted 26 entry interviews with 34 more scheduled this week and next. And I would say just when Cass and I were tabulating the numbers, that's a record even for me, who's done a lot of these entry plans. We had some long entry plan days, but really valuable and helpful to me. On Wednesday afternoon, I met with Mr. Chris Price along with Mrs. McCammon and Mr. Maroney as an introduction to the HHR Building Committee. And then on Wednesday evening, I attended a virtual meeting of the HHR Building Committee. From all reports, the projects are proceeding according to schedule, and we will be all ready to welcome our students back in August. And next Tuesday, I'll be taking a full tour of the sites to see the progress firsthand. I've actually been to the sites already, but this is a deep dive tour with Kevin Monrett. Last Friday, Mrs. McCammon and I had a chance to meet with First Selectman Zagrodsky and Board of Finance Chair Palin. It was an introductory meeting that allowed me to introduce myself and share a little bit about my background with them. I appreciate that they took the time to come and meet with me. And on today's agenda, there are two discussion items that will be very helpful to me as I transition into the role of interim superintendent. First, we'll spend a bit of time on a discussion about governance and governance team strategy. Thank you in advance for reading the chapter from the governance core for today. For me, it is crucial that we as a team are on the same page with regard to our roles and responsibilities for both the administrators and the Board of Education members. It's my hope that we will reach that shared understanding as a result of the discussion today. Being new to the community, it's important that I not work from assumptions, but rather develop understanding through discussion and research, a key reason for my entry plan. I look forward to that discussion today. And second, in reading the strategic plan and the district board goals from last year, it struck me that there were some key gaps and some unnecessary fuzziness. That word has come up a few times this morning. I've attempted to separate out two sets of goals in an appropriate manner and I've got a suggested path for the discussion that would create standalone goals for the board and leave the district goals as currently stated as a work in progress growing out of the strategic plan. Similar to the previous topic, I look forward to our discussion. Darien Summer School has two exciting musical theater productions this week. The Darien Summer School and Enrichment Junior Musical Theater Workshop's presentation of the Aristocats Kids is July 24th and July 25th at 11 a.m. at Ox Ridge Elementary School. No tickets are required for this free event. The Darien Summer School's Musical Theater Workshop presentation of High School Musical Junior will be at DHS on July 24th and 25th at 7 p.m. or July 26th at 2 p.m. Tickets are just $10 for adults, $5 for kids, and can be purchased at theater308.org. Lastly, after 1 week in this new role, it's clear to me that everyone I've interacted with, from faculty, staff, administration, Board of Education, and community members, all share a common priority, and that is providing a wonderful educational experience for the children of Darien. There is incredible pride in the schools and so much for us to celebrate. Thank you again for this opportunity.
Thank you so much. Again, thank you for being here. Okay, with that, we'll move to board self-evaluation and Board of Education goals. So I'll actually turn it back over, even though this is really us taking a look at ourselves. I'll turn it back to Eric for some of the information he has for us to get us started.
So last week, in preparing for the retreat and contacting Kate and having some conversations with Nick Caruso, I thought it would be helpful just to share a little bit of information in terms of the self-evaluation surveys. And I did include in your packets the overview that Nick prepared. I asked that he not come today because I think, you know, there were 4 contributions to the survey, and his presence would have been better if there was a more representative group. But I do just want to bring up the areas of greatest need that he identified through the responses to the surveys. And then I think some of this will obviously come in part of the discussions, I hope, that we've crafted for today. So just in no particular order, just was identified that the areas of greatest need, community leadership and community engagement. And that was certainly something that I've heard from all of the conversations I've had last week, is leadership and engagement from the administration, but also in terms of the board's work with the community. A discussion that there was a little bit of this morning around board ethics. And then the third one, which I think today is an important piece of this, is the governance team. So the board superintendent relationship, how we follow the chain of command and communication protocols that are set, and really being focused on that. So I wanted to set that aside because I thought the other pieces of the conversation would be most helpful, but any thoughts, comments, questions on Nick's summary that he provided?
Can we know who actually put them, the 4 people were, so we kind of know where they come from? I was one.
Yeah, I don't know that answer.
Perfect.
Yeah, my understanding is that he had some trouble receiving them. And I wonder if there might have been more than 4 and maybe.
There could have been an issue with things going into spam folders. I understand. We can certainly approach it differently the next time we do an evaluation
Thank you
and
all.
ensure that everyone has them.
If we do have a problem with just getting everyone to do it, I wonder if we might, the meeting before, just fill them out in person and scan them or something as well, if that helps with us just doing it at one moment in time. It's a good idea.
I think it could also be helpful in thinking about next year's retreat, actually doing this now, thinking going through it. I always found it helpful in my previous district with the board. We actually did it all at the retreat. It was a different kind of retreat in that we were active, moving, we were in small groups, individual reflections, then partner reflections. And it really was built into the retreat. You have a tremendous responsibility and a lot of things to prepare and read and digest before coming to meetings and coming to events like this. And it could be something that could be a really valuable modification if the board chooses to do it. I mean, I'm certainly happy to share those kinds of experiences and what I believe the board in Rye felt it was a very valuable part of the summer retreat each year.
Thank you. Yes.
I guess a question there. Did you guys have to be on tape? I mean, that's kind of why we're in the format here. It's just for FOIA requests. I know this is not the most conducive to, you know, it doesn't feel like a retreat to me. It feels like a regular board meeting.
right.
So did you have that limitation as well? And if you did, how'd you get that?
So meetings were recorded and posted.
Okay.
During COVID, when meetings couldn't be in person, they were virtual, but that lasted, you know, for a year. And then it was discontinued. There wasn't much public participation at that point through live streaming. But all the meetings were recorded. But in New York, and we can certainly consult the attorneys on this, a planning retreat was essentially an executive session. There were public portions of the retreat. So the retreat would adjourn and then they would reopen a public meeting that had a specific public agenda. And that was the format of it. And the summer meetings, and I could check legally how this happened. They weren't typically recorded because they weren't on site, but they were public meetings. They were noticed as public meetings. They were, agendas were put out according to the law and the open meetings law. But yeah.
Thank you for that background. I mean, if there's other formats or breakout rooms or other things we can do that are legally compliant, then, you know, hopefully we can talk about those moving forward.
Sure. And they were off-site at a community space that was available for use by the board, which made it feel a little different, a little more, as you said, more like a retreat and less like a meeting. Certainly something I can share those experiences with the board and possibly craft possible opportunities going forward.
Okay. Thank you. Any other questions on the CABE? Okay.
Okay, all right, so we're gonna try and do a retreat-like thing and have a protocol-based discussion around the text. So what I'd like to do is just, if you haven't had a chance to read chapter 2 from the governance core, and I do have full copies for all of the board members and administrators in the team, knowing that the governance team is the board and the administrative team. I will certainly, if anyone would like a few minutes just to read through, what I would suggest our way of approaching it is tackling it by section. So there are 4 sections in this chapter, which is entitled The Trustee Governance Mindset. And after the introduction, there is the opening section on the mindset, then you have the systems thinking section, the strategic focus section, the deep learning, and then the 4th is the manner. So I don't know how to do this, but does anyone need a few minutes to maybe just go through the first part, which would be the introduction to the governance mindset and the systems thinking? Or are we ready to just go ahead forward?
Yeah, it was in our packet, so hopefully.
Okay. All right. So what
You're not gonna test us on it, right?
well, we'll know on the recording whether or not any of us have read it, because the reason I choose protocols, and I do this in my work with my colleagues, do this with work with teachers, with other superintendents and principals. It's just a helpful way to structure a conversation so it doesn't go off the rails. Also, it's a helpful way to ensure that people have a voice. And I selected the 4A's text protocol, and I really think it's an interesting one to use because of what the frame is, which are 4 questions that you should be thinking about when we're discussing the text. What assumptions does the author of the text hold? What do you agree about within the text? What do you want to argue within the text? And what parts of the text do you want to aspire to, or us as a governance team act upon? Now, with most protocols, there is timing, you're supposed to have a facilitator and a timekeeper. I have found that in a setting like this, it is much better for us to just try and stick to the protocol in general. I don't think any of us will go on and on too long, but if there seems to be something going off track, I will call time out and just say, perhaps we should recenter on the 4 questions and the section that are available. But what I would suggest is, as we go through each round, so we'll take each section, so the first section, and then we'll go through the 4 questions, and giving an opportunity for anyone at the table to weigh in on your thoughts, your feelings, citing the text, reading the section if it's of interest to you, and sharing with the group. Go through the 4 questions, and then go back to the second section. So questions about them. And I do really love wait time, so I'm going to give lots of wait time. Okay. All right. So if we think about the trustee governance mindset and that first section, which I think is a great overall, and Tom Mooney mentioned governance a little bit earlier, but let's just jump right out of the gate. Assumptions that the author holds in that section of the text. Any thoughts? Any citations that were of interest to you?
I really like that it's just before the systems thinking, but I really like that set of 7 bullets about what having a governance mindset means. I think it's something we toss around a lot, but I think a lot of here, I think it comes up in board meetings, keeping the board's focus on the children, watching the budget, keeping focused on the long-term goals of the organization, building and maintaining a strong governance infrastructure, policy, supporting the staff and creating a positive organizational culture, holding the organization accountable to the community it serves, which has to be tied with the one right before and at the same time, and keeping the constituents of the organization informed and up to date on the work of the organization. And those constituents, of course, being all of our stakeholders, students, staff, families, fellow government bodies, et cetera. community organizations. I love that as a sort of just organizing principle for what being on the Board of Ed means.
I think that that first A, that assumptions, what does the author of the text hold? I think the first assumption is that the author holds is that everybody at this table wants to assume a governance mindset, and that everybody kind of has to buy into that in order for the governance mindset to work. The other thing, that the phrase that stuck out to me was that having a governance mindset means becoming aware outside of your own personal state of awareness. And it's referred to as an attitude, not an agenda. And it's not necessarily what the topic is at hand that is being discussed, but how you are approaching that topic.
I think it's one of that last piece is one of the trickiest pieces of being a board member. I started when all of my children were in elementary school, for example, and we would talk about things that were happening at the high school, which I didn't have direct experience of. So you just have to figure out. And I don't actually think having kids in the school is the, Dennis and John, like I think being on the board is a higher level than that. You're not just, you are picking curriculum, but it's not really just about your children. It's about how you run an organization effectively for the town.
I think that's on page 30, toward the bottom. I highlighted having a governance mindset means establishing an internal balance between conflicting and very different values, concepts, intellectual positions, and core beliefs of the board. Being an elected member of the Board of Education is always a tricky balance because of you're serving the students, you're serving the system, and there are always competing interests that come into play, and it's through the governance mindset and focusing in that manner that I've seen the most success with boards navigating that is when they find that balance. Ron?
I agree with those comments. The bullet points I think were really helpful, just in terms of keeping us on track on what the real core responsibilities and mindset are, because I think sometimes we definitely tend to get into the weeds on things when I think we need to really be cognizant of trying to keep it at a level where the action items and the things that we're really honing in on are allowing us to get to these outcomes in terms of supporting or building or watching the budget or holding people like just to keep it at that more strategic level. And I think it's very easy to slip into getting into all the details, which are going to reference later, because we're very agenda driven and it needs to get extremely operational. So I like this as an introduction because I think we have to keep in mind, even when setting agendas, how to kind of keep out of the operational piece and make sure that we are being strategic. And that can be a tough thing to do that we should talk about. I think that's a little bit later.
Joanna?
One sentence that really jumped out to me is that a high-performing trustee knows that excellence in governance requires purposeful action. And I underline purposeful action because I feel like the assumption is that everybody, like Sarah said, is here for the same reason. And even if we're not here for the exact same reason, I feel like we often get stuck in the what and not the why. And the purpose behind the what is what I feel like the board as a whole could keep coming back to more often than it already does.
I also think these are tough jobs, and that tending to that mindset and staying there is really important. And what often I've seen is that you get so focused on the work that you don't actually go back to how are we functioning, the reflection piece. If you're having conversations just to sort of check in and how are we doing with this? Or is this something that's working well? Or are we staying on task? I think those are important conversations to have. And they shouldn't have to wait for an annual retreat or a formal survey that comes from an outside organization. I think you can tend to that as a board and as a governance team and sort of check on that and work at it, because this is not a natural place to be. This is a place you have to work toward, and it takes time and it takes effort and it takes study and practice. Any interest in arguing with anything in this part of the text so far? Go ahead, Katie.
It's not really an argument, but maybe a bit of a gap. Having been involved in similar but different other organizations that are volunteer driven, that are temporary, I think that it's important to remember that we're stewards, that the Board of Ed doesn't belong to any one of us. Darien Public Schools, it doesn't belong to any one of us, but it belongs to all of us. And that we are merely temporary keepers for the people that are coming after us. And I think that's a really important mindset, just to remember that this is bigger than us, that people came before us, that people came after us. And I think it's really important to have that future thinking lens in terms of what we might be doing to make things better for those come after us, and what, you know, challenges they might face.
Thinking the long term, the long game.
I think that one of the important pieces of the sort of governance mindset is also understanding, as part of that long-term view, but just for how you govern. I think that we've done a lot of work in the recent past on understanding state statute, understanding how that affects local policy. And we need to continue to understand that those are our organizing principles, and always go back to those and how the policy reflects what we're trying to accomplish, and what our boundaries are based on law that happens outside of this room.
So I'll just suggest any parts of this section that you wish to aspire to or act upon, having read through it, just any ahas?
And the one sentence that I think we should all act on is that, I guess the bottom third paragraph of page 30, it says, the last sentence, developing this mindset first often requires a shift in thinking. We call this shift moving from I to we. And I think as the 9 of us, myself included, I think too often we think in terms of I, and I'm hoping that we can get to the point where we're thinking in terms of we.
And then thinking in terms of we isn't necessarily that you always agree with each other,
Correct.
but when you take action as a full board. Anyone else? All right, I'm gonna shift us to systems thinking. I really
Robin,
like
sorry, go
this.
ahead.
Oh,
Just
Robin, I'm
one
sorry.
On the bottom of page 30, where it's talking about they learn what works and what doesn't, they intuitively understand that the board must work together as a governance team rather than a group of individuals meeting in the same room, moving in many directions with different agendas. They recognize the importance of coherence both within the board and within the district. So I think that's kind of a key concept that I think every one of us individually probably has many different ideas about what we think would be best, but it is a challenge, but I think we need to kind of make sure that we're coming together in the name of keeping those goals in mind, which are the bullet points of what are the overarching reasons why we're all doing this, which is for the students and all, you know, the other kinds of key things that we're out there just to keep us at that level where we can shift our thinking and discourse toward those common goals.
Greg?
So this is more of a comment on like the structure, and we kind of talked about this a little bit in terms of we're on video and all this kind of stuff, but I do think that I've been on other boards, I've advised boards as part of my career, and I do think that the way that we hold meetings is counterproductive in terms of getting to this place. And what I mean by that is we don't have a forum to have open dialogue. Like it's unhealthy for a board to only have dialogue in front of cameras where no one can have like real conversations about key issues. And so what happens then is you have tension in the room as a result of that. And so I don't know how to fix that problem, but it sounds like you may have some good ideas, which me personally would welcome. I think others on the board would agree.
I certainly don't have an answer for us being recorded and meetings being recorded because we do have to abide by open meeting laws. But I do think there are ways to do that. I've tried some that have failed spectacularly and some that have been incredibly successful. I've worked with boards when we've read an incredibly challenging divisive text together and discussed it as a board on camera for everyone to see. And it was a really powerful meeting. It was one of the most powerful board meetings I've ever been a part of. It was not an easy discussion by any measure, but everyone at that table was committed to do it in a manner that was consistent with this governance mindset and with how does this best serve our community and our schools. So again, I can certainly try and help affect some change on that end of the spectrum and think about and collaborate with you and the administrators on how do we make meetings more like that? Because I think there are some simple technical things that can happen. And over time, being this is my first one in front of the cameras here, my first one with all of you, I'll certainly be willing to share all of that. Because what you want to be careful of is you don't want it to appear that you're changing practice and lessening any kind of transparency or openness with the community. But I would suggest that one of the things that came up in the summary document from Nick Caruso, something that has come up in my entry, is communication and trust and confidence in my office by the greater community and by the board. And so if the information is flowing to the community in a way that is sensible, simple, clear for everyone to understand, and that's happening regularly and transparently, then I think we can get to a good place.
I have, as part of the company I work with, we have quarterly meetings and there's ground rules for those. And one of them, I'm reading it, is agreement is optional, commitment is not.
Can you go, I like that, but can you talk about that a little bit more? How do you apply that on that?
It just means we have very healthy debate about everything. But then once we come to a conclusion and we have, there's a CEO, there's other people who make the ultimate decisions. Once we come up with a decision, the path to move forward, commitment to go on that track is not an option. You have to do that.
Right, so you may have a vote that's not unanimous, but you're all supporting that decision once it's made as a full board.
Correct.
Yeah, I think that's an area this board can think about a little bit.
I'll just, in the broader sense, I think this is an awesome exercise because as we look for a permanent superintendent, there's a lot of microscopes on us right now in terms of how we act, how we vote, how we interact with our administration. And I think it's a perfect time for us to kind of reflect on all that. Because I kind of feel that people are going to be interviewing us through watching our board meetings more so than you ultimately will be interviewing the final candidates.
You are 100% correct. The quality candidates are going to do that. I watched almost a year's worth of board meetings before I met with you. So, and that's just, I mean, there was a lot of time. You have long board meetings, but candidates do that.
Yeah.
And they show up in town. Before I became the superintendent in Rye, before I was even a candidate, I had more meals in Rye than I ever had before. Just listening and learning about the community, observing, seeing what was going on. Shirley, you know the community well. There's a lot of good eating in Rye, so it was easy for me to do that. But it really was, you approach this, it's like an anthropologist when you're looking. Because you want it to be the right match for the board. You want it to be the right match for the community. And you want the individuals knowing that it's the right match for them. Because they really need to come in eyes wide open, knowing what the challenges are, what the concerns are, and what the community is they're going to. I've seen far too many superintendents that just want a job as a superintendent, and they'll take the first one that's offered to them, and they haven't done their homework, and they don't do their entry, and it's an abject disaster. And a year or two out, everybody's negotiating a settlement. Separation. All right, ready to shift to strategy? I'm sure my colleagues are going to jump in on this one because there's some really good examples. There's some very specific examples in this one. So wait, this is systems. I'm sorry, systems thinking, yes. Okay. Just open it up. And I won't state the questions. I think we're on the right track by covering most of the questions. So this is where you can sort of shift away from a protocol if it seems to be working very well.
Well, I think I'll skip ahead to the what do I want to act upon? I think this is where we do get a little bogged down and have been bogged down in the past is are we thinking up here or are we thinking at the minutia level? And that helicopter metaphor was very accurate. You know, the sentence, this is not the job of government, that is the job of the experts hired specifically to handle the problem. And I think we have excellent people working in this district and there has been in the past an erosion of trust and so that rebuilding that so that we feel comfortable getting out of the weeds is really what needs to happen. So I'm aspiring to that.
So I would say, an aspiration of mine, and it comes from your words, not necessarily in the text, but trust comes from competence. And we need to ensure that we are competent in all of our roles so that trust begins. And that starts with me. I need to show you that the job you hired me for, that I could do it well, and I communicate appropriately with you and the community about that, and the trust will grow. But loving the helicopter, loving it. Trustees, so on page 34, sentence goes on about Sherry. Trustees needed to be in the helicopter making system decisions, not on the fire line fighting fires. And then secondly, note to superintendents, if you put a fire hose in the hands of a trustee, they will get out of the helicopter and fight the fire. I think that is a great message for this chapter. I'm sure you all appreciate that. Although you might not say it. I'm an interim. I could say things like that, but.
We're gonna hear that a lot lately.
Yeah, I liked concept of actions are not taken in isolation, of understanding that we need to be thinking about the implications on the entire system when they talk. I think that a lot more of what we do is complex. And when we talk about that, for example, specific to reading, and that you can't look at that just through the specific initiative, you also have to be thinking about the impact on the older kids. You also have to think about the impact on children who are receiving specialized instruction, you know, whether that's through MTSS or whether that's through a specifically designed program. So I think we've been moving more in that direction of looking at things from a more systemic point of view when we evaluate. But I agree. I think this continues to be an area of work.
And I think for a lot of communities, I'm sorry, Sarah, COVID sort of forced you into a place where you were putting out the fires. It was an all hands on deck. We're out of it. Yes, there are still ramifications post-COVID that we have to navigate. But in terms of trustee and board service, you should be able to get back in the helicopter at this point, not